Good morning, everyone, both here and on Zoom. Just before we get started here, just a reminder for folks who are interested in the Docker tutorial immediately after the coffee break at 10:30, just go to the Slack general channel. There's some instructions there about installing Docker. We're not able to run Docker in the Jupyter Hub, so you will need to install Docker on your own machine in order to participate in that tutorial. So that's for the one at 10:30. So we'll have the coffee break to take care of that. If you're running into any issues, then Slack us or find us during the coffee break, and we'll help sort you out. For now, let's get started with today's program. We have Damian Eek from University of Nottingham, who was supposed to be here in person but wasn't able to make it in the end. And we're really, really grateful that he's joining us over Zoom, and he's going to talk about a topic that I think is really interesting and important and relevant for everything that we're talking about here, and on which Damian is really the world expert, possibly really the only person who has all the pieces of the puzzle. So we're really lucky to have him tell us about this. And with that, I'll hand it over to him. Damian, take it away.
Okay, thank you very much, Ariel. Can you hear me properly?
Yeah, that's great.
Good. Again, I'm so sorry not to be there in person. I was planning to until a few days ago, and I fell ill. Maybe there will be opportunities of meeting all of you in person next time. So today I'm going to talk about responsible data governance for neuroscience, the role of ethics and the law. And I know maybe bits of data governance in neuroscience you're already familiar with. If you're familiar with metadata standards, you're already familiar with governance approaches in neuroscience data. If you're already familiar with other bits of technical or issues regarding access control and how to make data fair. But I think what is not really common in neuroscience is understanding the role of ethics and also the regulatory provisions that can help us to do things in neuroscience. So for this, today we're going to understand the meaning, the nature, and the scope or rationale for data governance in neuroscience. Also try to identify the role ethics and the law play in effective data governance in neuroscience, and be prepared to identify and address some of the data governance issues in some of our data pipelines. So, but the first thing that we need to do is to understand what is neuroscience data. Maybe you're familiar with this diagram from a paper we published a few years ago. So traditionally, we know neuroscience data as the raw measurements, or whether it is EEG, MAG, fMRI, PET. Those are raw measurements that we understood as neuroscience data. But with the convergence of technologies in neuroscience and the help of data science and other technical elements, we now know that that's not the only thing that we can refer to as neuroscience data. Because with raw measurements, we can create models, and these models are also called neuroscience data. But they are not at the same level or the same level of sensitivity as raw measurements. But combination of both raw measurements and models are now what we can understand as neuroscience data. So there's an increasing need to share data sets, both models, both software, and also the raw measurements. There's increasing need to share these data sets. The need may be by your funders, because there is a requirement for funding. And also it is important as a cost reduction mechanism, so that you don't collect the same set of data set that somebody else has collected somewhere else. So it will definitely save cost. That's one of the increasing drivers or factors for sharing data. And also the need for reproducibility. That cannot be overemphasized. But I think maybe with Ross there, you may be familiar with the concept of reproducibility now. and also the possibility of increasing your citation. Because one thing is to do your research, collect these data sets, run your experiments, and then publish the findings. But also, if you share your data sets in a repository and make it available for other people, that increases the visibility of the paper your findings will have. It also gives you possibilities of increasing your citation because data sets are also cited. And some people might feel it is simply the right thing to do. Data sharing is something that we need to do. Or some people are doing it because they feel it's the right thing to do. However, there are a number of barriers to sharing. One is legal requirements, ethical concerns. There are also organizational barriers, technical requirements, and wider sociocultural concerns. You may well know that there are legal requirements that can prevent you from sharing your data sets. GDPR is often the elephant in the room. If you know the EU General Data Protection Regulation and other local regulations these days do not make it easy for people to share their data sets. And also there are ethical concerns as well as organizational barriers. So most times, most institutions or organizations prevent people from sharing because they are afraid of liabilities in terms of data breach and all that. But some of these issues that we're going to unpack them today. So, and because of these barriers, that is why we need a data governance mechanism, a governance mechanism that can help us to effectively understand what we need to do and provide us with practical guidelines on how to effectively go about them. Because at the moment, the current landscape of these concerns and these barriers look like this. If you look at the diagram, the A part of it is how the situation is at the moment, because we all have this burden of regulatory oversight because the archive, there are requirements for data archiving systems. There are journal requirements, there are funders policies and requirements, just like the NIH data management policies these days, and also institutional requirements, as well as national laws or data protection laws in the different countries. And then at the international level, there are also treaties and agreements for us to look at. So researchers like you feel as if you're overburdened with all these requirements and provisions that you need to look at while you just want to get on with research, because this is not what you bargained for when you wanted to be a scientist. So what we need is an international data governance in such a way that we can understand what happens in the different regions, what happens in the different institutions, in such a way that we can freely understand what is happening and freely share our data sets in such a way that we can collaborate effectively and help other researchers in other regions to work on our data. So, but what is data governance? I think after so many slides, we've still not defined what data governance is. There are two definitions I'm going to offer today. One is by Fortigel et al., who define data governance as the overall management of the availability, the usability, integrity, quality, and security of data in order to ensure that the potential of the data is maximized while regulatory and ethical compliance is achieved within a specific organizational context. So this shows that what you have already started dealing with in your labs, in your institutions, in terms of data quality, data quality assurance, in terms of security, in terms of data usability, in terms of data integrity. All these are elements of data governance. But in our paper, which I also referenced earlier, we define data governance as those principles, the procedures, the frameworks, and the policies that we set up in our institutions or in our projects to ensure acceptable and responsible processing of the data at each stage of the data lifecycle. Also, we introduce the concept of the data lifecycle in this definition, from collection, storage, processing, curation, sharing, and deletion. Oftentimes, some of these stages of the data lifecycle are forgotten, especially deletion. But that's also an important aspect of data processing pipelines. That is very important. And there are data governance mechanisms at that stage too. So fundamentally, data governance is about the people, the processes, and the technology. All these aspects of the people, processes, procedures, and technologies that provide an effective and functional data processing ecosystem that not only benefits the organization, but also that is compliant with the law and ethical principles. So that's a lot. This is a lot for researchers to actually unpack, but having a framework of understanding who is responsible, how is does this person need to have access to the data? What procedures do we need to follow? What policies do we need to set up? And what technology do we need to embed into this process? It's very important in understanding how to manage data governance issues in your institutions. So data governance, as I've just described, is not just about data protection. It's not just about the law, because some people feel, what is the law for us to look at here? Okay, yeah, here is the law, here is the GDPR. Is that the only thing about data governance in neuroscience? No. It's not just about data management. Oh, we have been writing DMPs, data management plans forever. What else do you want us to do now? It's not just about data management. And it's not just a gotcha process. It's not a process where we set up all these things to get you to make sure that, oh, now we understand that you're not doing this. Now you're in for trouble. No, it is not a gotcha process. Data governance mechanisms facilitates fair. And this is something that we are very comfortable with. This is a concept that we're very comfortable with: definable, accessible, interpretable, and reusable data. Data governance mechanisms, be it the ethical element of data governance, be it the regulatory part of data governance, or the technical aspect of data governance, actually facilitates FAIR. But in FAIR, from what we have dealt with in literature, in our practice, and in curriculum, most often FAIR is almost fully focused on the technical aspect of data governance, the technical infrastructure to make data findable, the technical tools to make data interpretable, the technical tools to make metadata findable and reusable. That is what we know FAIR as, but not just that. There are so many aspects of the legal issues. There are so many aspects of the ethical issues that can actually affect findable data, that can affect accessible data, that can affect reusable data. So it's important for us to also identify those legal elements, those ethical elements that is involved in FAIR. So that means it's not just about FAIR, but there's also an element of compliance that needs to be part of FAIR. So what is missing in our current attitude towards FAIR is compliance. So definable, accessible, interpretable, and reusable, but there has to also be compliance. Compliance to ethical principle, compliance to legal provisions, compliance to all the necessary laws and data protection provisions that are related to what we're doing in data processing, data sharing, or data deletion. So it's about compliance with ethical principles, the technical requirements, and this is the technical requirements is something that we're very familiar with. The legal provision, also societal expectations. There are societal expectations that we need to look at, we need to address, we need to consider in also the processing of the data. I give you an example. I think last month I was in Vienna for FANS, and part of the IBRO events that happened in Vienna. So we had interactions with people with lived experiences, and we had all these assumptions of how data processed from people with lived experiences can be handled, can be addressed, can be protected. But then there were some people with lived experiences in the room who have different opinion about how that should be done. And that is a social expectation that should also follow us in most of the things that we do in data processing. So the technical requirements, some of the technical requirements that you might be familiar with, or maybe you're going to address in in the 2 weeks that you have in Seattle. Metadata standards, BITS. If you're familiar with BITS, you're already familiar with some of the technical requirements for data governance, storage infrastructure, or having a storage system where other people can have access to the data and the data is findable. And also cybersecurity, making sure that the security of the data is watertight, making sure that if it is sensitive data, if it is data of individuals, you do not have data breach or data, and also maybe developing technical processes to protect the privacy and confidentiality of the data subjects through anonymization. Or please, if you have any question, you can raise your hand up and stop me so that I don't talk at you for 1 hour, please. If you have any questions, please pull me back and I can answer the questions. So these are some of the technical issues. And then the ethical issues. There are so many ethical issues in every stage of the data lifecycle. In data collection, you can encounter issues of data minimization, informed consent issues, making sure that the data set is collected with adequate informed consent from the data subjects, public data issues, or inaccurate recording of the data, or sampling bias, or also maybe participation bias. An example would be if you're conducting a research that should span across genders, and then you only have one particular gender as your study participants. So there are so many ethical issues involved in data collection stage, and also regulatory differences involved in data collection, and also data processing. There are so many other issues there in terms of data integration or aggregation. How do I integrate data sets from different formats? And then the lack of data governance at that stage is also a problem. And then data curation has also other issues in terms of data process, in terms of pseudonymization or anonymization. Do you need to, in neuroimaging is about maybe defacing or score stripping to make sure that the identity of the data subject is preserved, the privacy and confidentiality of the data subject is preserved. Also data sharing, there are so many data sharing ethical issues at that level where you think about third-party issues, international transfers, which are regulated differently in the different regions. And also there are issues ethical issues in data deletion, where you have unintended deletion or inappropriate retention of data, exceeding the number of years that you need to retain data. These are ethical issues that can affect data findability. These are ethical issues that can affect data accessibility or maybe reusability. One issue here that I want to highlight is maybe something that can happen at the level of data collection that can affect sharing, that can affect reuse, which is maybe regulatory differences in data collection. And one will be animal welfare differences, because in different regions, animal welfare is addressed differently. And this is purely based on sociocultural beliefs and cultural acceptability of some of the things that we can do with animals. For instance, in Africa and Europe, the idea of animal welfare is completely different from each other. How we treat animals in the US and EU is also not the same with Asia. An instance will be this research, which I usually give as an example. I think it was in 2019 that this paper came out, where a group of researchers from Asia and a few from the US actually published this paper. And the idea was to use human gene to create a transgenic monkey. And when the paper was published, it garnered a lot of bad press, because the research activity that led to this finding, people were saying that this could not have been approved in Europe. This could not have been approved in the US. But why did people do it? It's because it can be approved in Asia. Then after the bad press, this is some of the headlines that actually came out then. So many headlines were very negative. So after that, and this quote from Martin Steiner actually exemplified what other people were thinking. There are a bunch of aspects of this study that you could not do in the US. So a few of the, I think one or two of the authors from the US had to denounce the research, had to publicly denounce the research. So it's important, sorry. You've lost my screen, right? Yes. Sorry about that. So there are so many, what I wanted to highlight here is that there are so many ethical issues that can happen at the level of data collection that can affect sharing. So now what we did, when this paper came out, what we did in Europe, by then I was the data governance coordinator for the EU Human Brain Project and eBrains. So what we did was to evaluate the process that they used to collect the data and use that as a template for what we can accept as part of eBrain's data or what we cannot accept. And from our analysis, many aspects of what they did in this research could not have been approved in any country in Europe. That means we will not accept it in eBrain's research infrastructure. So this type of ethical issue affects sharing. And there are so many other ones, so many examples that we can find both in human data collection and also in animal data collection. So there are also legal concerns that we encounter in the different stages of the data lifecycle. One is privacy and data protection, informed consent. Informed consent here, there are two sides of the informed consent here. One is the informed consent used as part of the research protocol for any biomedical research, which is normal. You should do it. But also there's also another aspect of informed consent to use the data as a legal basis, to use this as a legal basis for processing the data further. Beyond the research, can you use this data for something else? Do you have consent from the individuals or data subjects to use the data for something else? That's also another aspect. Most of what we do before now involved the first example, which is getting informed consent to conduct the research. Most times we forget the informed consent to use as a legal basis for processing the data beyond the research project or the research activity that we are at the moment. So that informed consent is both an ethical issue and also a legal issue in that aspect. And then there's also the aspect of data ownership. Most times, as researchers, we believe that we own our data, but there are nuances to it. If the data involves the data of a data subject, if you have participants and you collect data from them, are you able to own their data? Are you able to own that data? One reason in Europe, you can't own that data. In the US, I think it's also the same, unless somebody tells me otherwise, where the data is owned continually by the data subjects. The data subjects that you collected data from own their data because it is their personal data, it is the identifiable data, and it's their own. You can only be the data controller of that data or the data processor of that data, but not own the data. So that is why most times, if you have data and you put CC licenses on it, if you put a license on it which shows attributes ownership to yourself, is it the right thing to do? I think I will elaborate on that later on. And then there are also data controllership issues. Who controls the purposes and means of processing the data? These are legal issues or addressed in the law. There are also international transfer issues and also regulatory differences. Just as we have addressed, we've talked about the animal welfare issue, but also there are regulatory issues in terms of differences in terms of data protection regulations, because the data protection regulation in Europe is not the same way it is in the US. It's not the same way it is in China. So there are differences. How can we harmonize all these regulations to understand what we need to do at each stage of the data lifecycle? So what we do, legally, there are things that we can do. And these suggestions are based on my ideas of the GDPR and similar laws related to the GDPR. One is identify in anything you do in terms of data processing, identify the legal basis for processing. If you are processing the personal identifiable information of any data subject, human subject, you need to identify the legal basis for processing. And this is based on some provisions in the law. One of those provisions can be informed consent, but it's not the only legal basis for processing. And I'm going to elaborate on that later on. And then after identifying the legal basis for processing, you need to identify technical and organizational measures that can help you to safeguard the privacy and confidentiality of the data subject. One of those ways to do it is to conduct a data protection impact assessment, a DPIA. And this is a very light process of identifying the risk involved, the risk of breach, and identifying responsibilities and liabilities in terms of the data. Who is responsible for storage? Who is responsible for granting access? Who should have access? Who should not have access to the data? The data protection impact assessment can help you identify all these, and you record it and put it in a place where everybody involved in data processing activity will know about it. And then also, another technical and organizational measure here can be anonymization or pseudonymization. Anonymization of the data is the removal of both the direct and indirect identifiers of the direct identifiers. Here can be names of the individuals. Indirect identifiers can be brain prints. It can be other things that we can use to identify the individual, but not directly. And then pseudonymization is the removal of the direct identifiers, and the indirect identifiers are still in the data. If you remove the names, remove addresses, remove social security numbers, there are still other indirect identifiers in the data. If you do all that, it's pseudonymization. It's not called anonymization. Pseudonymization is similar to what you may know as de-identification. And then encryption. Encryption is also another technical and organizational measure that we can identify to help us to protect the privacy and confidentiality of the data subjects. In addition to identifying the legal basis and also establishing technical and organizational measures, you also have to select or write up relevant agreements necessary for you to protect the individual. One is the data use agreement. In access control mechanism, DUA is very important. Data transfer agreements, data processing agreements, and joint controllership agreements. And I will elaborate on all of this soon. So, and I've mentioned personal data, I've mentioned data processing, but what are these? The GDPR, like any other data protection regulation, defines, applies to only personal data. And personal data here will be any information, any data relating to an identifiable individual, human being. So if you're processing animal data, the GDPR or any data protection regulation does not cover it. So if you're processing an information or data related to an individual or identifiable human, then it is personal data. And processing here will be any operation or set of operations which are performed on personal data, from collection to sharing to storage to processing to application. All these are all these are data processing activities on the data. And this is something that also confuses a lot of people, or maybe a lot of people don't understand. What do you mean by identifiable individual? Or identifiability here will be if anyone can identify the natural person or the human being involved using all means reasonably likely to be used, then the information is personal data. The wording of this is very careful. All means reasonably likely to be used. The reason why all means reasonably likely to be used is used here is because of what we call the test of re-identifiability. Because the way a data set can be tested to know if you have performed full anonymization on it or pseudonymization on it is the test of re-identifiability, considering the time that it can take an individual to identify the person. If it takes maybe a year or 2 or 3 years or 4 years of working on the data to re-identify the individual, that is a lot of time. And that might not count as a personal data. And also not beyond time, there's also cost. How much will it cost an individual to identify this natural person? If it costs maybe $500 or maybe $1,000, that's little amount of money that it can take one to re-identify an individual. But if it takes maybe $10 million to re-identify one individual, then I don't think that data is personal data because it can count as anonymized data. And then another thing is the availability of technology. Is there any technology available to this individual to re-identify the person? If there is if there's availability of technology to do it, then that also counts as all means reasonably likely to be used. Yep. Angelina.
Yes, Angelina, yes, thank you. Can I just quickly ask a question?
Yep.
Yeah, I thought that point was actually quite interesting about, passage of time and how that changes with regards to someone's identity. But then say you're fully able to identify someone like 20 years after their original data has been collected. So obviously that person will have aged and a lot of things will have changed, but what will be the correct thing to do in that case? Because surely you wouldn't want to be able to identify someone even if that's decades later.
So I think there are 2 issues in the question there. The re-identifiability that happened 20 years after, did it take 20 years to happen, or did it take maybe a week for the person to re-identify the individual?
Yeah.
If it took 20 years, I would say that data was fully anonymized before that. That's fine, because that's a long time to conduct a re-identifiability test on a particular data. But if it took maybe a week, then there is a possibility that that data is no longer anonymized, but pseudonymized, because this changes. It's kind of a moving train, because if there's no available technology today, there might be available technology tomorrow. If it takes like $10 million today, it might take like $500 tomorrow. So what you count as anonymized today might be pseudonymized 20 years time. So it's a kind of a moving train.
Yeah, because then indeed, if we only assume that data is completely anonymized, if it can never, ever be re-identified, then actually what are we doing with the definition? Because like you said, we will probably have the means to identify people earlier, better, and cheaper. But then does that mean that the original study did something wrong, or that the data was not anonymized properly?
No, I don't think at the point when the data was fully anonymized, I don't think the researchers did anything wrong, because at that point it was fully anonymized. But 20 years down the line, if it is then considered not fully anonymized, then it changes. The definition of that data set changes.
Interesting, because that would have not been my original thought, but it's interesting definitely when you unpack it that way. Thank you.
Thank you. Thomas?
Yes, hello. I was wanting to ask something about, sorry, my camera's not working. I wanted to ask something about, so this relates to identifying one human individual, but it doesn't pertain to identifying a protected minority or a group of involves more than one human being. So does that mean that that is not something that GDPR is worried about right now, identifying groups of people? It's just worried about identifying one person.
I think your network cut critical bit.
Sorry, is it better now? Can I ask again?
It is better now, but you can ask the question.
Okay, sorry. So I wanted to ask, so this all relates to identifying one human being, but what about identifying a group of people, right? So that being a sensitive, let's say that there's sensitive data that identifies a protected minority or anything like that. Does GDPR worry about that, or is it really only about one-on-one match,
So
one-to-one match?
Yeah, this is a very good question. The GDPR, unfortunately, is about individual rights. It's not about collective rights, but about individual rights. So if you can identify individuals within that ethnic group, or maybe a group study, that means the liabilities or the definition of breach will be about the individuals. If there is a payment for fines, it will be about how many individuals were involved in this. But it's not about collective rights. But if you can identify one individual, the GDPR takes it as serious as if you can identify 10 individuals. Sai?
Can you hear me?
Yes, we can.
Yeah. So when you're saying like in the future, right? Like 10 years in the future, if someone is able to identify your data, so how are we saying things in the future? Like how, in what way can we estimate that, if that makes sense?
Okay, so this is another thing. The GDPR or maybe any data protection regulation does not think about 10 years down the line. It's about what is happening now. If at the moment there are technologies available for re-identifiability, if it doesn't cost a lot, if the time for re-identification is not a lot, then that is what we define, how we define the data. I'll give you an example. Years ago, if you're familiar with the idea of defacing of neuroimaging data, years ago, if you deface an image in Europe, even in Europe, it's anonymized. You can share that data with anybody. But just a few years ago, about 2 or 3 years ago, it became possible to use technology, available technology, to re-identify individuals even after defacing. So the definition of defaced data changed from anonymized data to pseudonymized data. And with the change of definition of that data, it changes the way we deal with the data, because all pseudonymized data are also personal data. That means that the provisions of the law still are still very valid in handling them. I don't know whether this answered it.
So there's still no way to estimate like if the data can be truly anonymized, if we can't truly provide an estimate of how long it will take, if that makes sense. Yeah.
Yes. And also sometimes I think I get this question: can we fully anonymize some data in neuroscience, especially neuroimaging data? Can we fully anonymize neuroimaging data? Because if we agree that brain prints are re-identifiable, can we fully anonymize brain images, and then they still have a high level of utility for research? Maybe not. Maybe we need to be satisfied with defacing and then defining the data as pseudonymized data and handling it as pseudonymized data, which does not mean that we are prevented from sharing it. We can still share it. We can still use pseudonymized data. Okay?
Yeah, thank you.
Okay, so I can also skip this because now I've exhausted a lot of time on GDPR. But what the GDPR defined 2 types of data here: the general personal data and special category data. The general personal data are direct identifiers like names, telephone numbers, your email address, your identification number, or your social security number. These are, for GDPR, general personal data. And then there's also the special category data of personal data, which are handled differently. They deserve special treatment or sensitive also to be handled with sensitivities in the GDPR. Your personal data revealing your racial or ethnic origin, your political opinion. But the one that concerns us in research is about data concerning health. And almost everything that we deal with in neuroscience data is data concerning health. That means we are dealing with special category data or sensitive data. So personal data, therefore, includes both pseudonymized or de-identified data, and also the raw data. But then, if it is fully anonymized, if there's a way that you can fully anonymize the data, or if it is postmortem data, or if it is animal data, then you can call it personal data. It is not personal data, and the provisions of the GDPR do not actually include them. It does not mean that there are no ethical or legal issues related to handling them. There are, but not for data protection regulations. So I was talking about identifying lawful basis for processing earlier. And some might be thinking, what are lawful basis for processing? In handling any personal data, you need to identify at least one of these legal bases for processing the data. Consent is one. I think I've mentioned it earlier. This is not the same as the consent you use as for the research protocol in biomedical science. That's completely different. If you want to use consent as a legal basis for processing your data, then in your consent document or information sheet, there has to be information there for the data subjects that this data will be used for this and this beyond the research. If you want to share this data in a repository and make it available, make it fair, then you have to make it explicit for the data subjects to select yes or no in the consent form. That means you have clear and explicit consent from the data subjects to use the data. But consent is not the only, as you can see, it's not the only lawful basis for processing the data, even in Article 6 here. There's also contracts. If you have in your workplace, actually, the reason why maybe your employer can use your data for what they want to use it for is because there's an employment contract there. There's also legal obligation necessary to comply with the law in terms of maybe if the police is involved, or vital interest. There's also public task. There's also legitimate interest. In most UK and EU universities, consent is discouraged from being used as a lawful basis, and public task is always identified as is one that is almost used in every university because there are legal implications of using it, and I'm going to talk about it later. But also, if you're dealing with special category data, especially the one we have just talked about, then you have to identify two lawful bases and not one. One from Article 6 and then one from Article 9. And Article 9 have more lawful bases here. And the one that concerns us is the one at the end here, which is archiving purposes in public interest, scientific or historical research purposes, or statistical purposes. Sometimes most DPOs, data protection officers, or researchers feel if I don't have consent from the data subjects, I can't share the data. I can't use this data. I can't process it. No, you can. There are other lawful bases that you can identify to help you to process the data. And one is archive for archiving purposes or for scientific interest or historical research purposes. So it's important for us to understand that, because sometimes I meet a lot of people, they say, we have loads of data in our archive, we have loads of data in our repository, in our institutional repository or in our lab, but we can't use it because we didn't get consent to use as a lawful basis for processing. No, even without consent for lawful basis for processing, there are also other lawful bases that you can identify to help you to process the data. So most often, people feel that the law impedes research. It's stopping us from what we need to do with it. No, the law is on our side. It's about understanding how to apply it to what we're doing. So if you these are some of the points that you need to be aware of. One lawful basis is always required under Article 6 for general processing or processing of general personal data, or for special category data, in addition to the lawful basis under Article 6, a lawful basis is required under Article 9. So, and these are some other points that you may want to be aware of. The reason why I talked about discouraging researchers from using informed consent as a lawful basis is this, because data subjects, your participants, have rights. There are certain rights given to them, and this is not just the GDPR, but if you're working in California, there are also strict data protection regulations in California. In Canada, PIPEDA is also there, and they are trying to improve it also. There are so many data protection regulations that actually identify some of these rights. The data subjects have the right to be informed always, and that this always applies. The data have the right of access, always apply, access to their data. They have a right to rectification. If there's a mistake in the data you have about them, they have a right to rectification, and that always applies. And they have a right to erasure. That does not always apply. It does not always apply, especially in research. Imagine collecting data sets from 500 participants, and then 200 comes to you to say, please delete our data at the middle of the research. That will put spanner in the works. So, and then the right to restrict processing, it doesn't always apply to, and the right to portability, the right to object to your processing, and also a right related to automated decision-making or profiling. But why am I talking about all these rights? It is important because the type of lawful base you select, or the lawful basis you select for processing, determines what the data subject can actually ask of you. If consent is one of your lawful bases for processing, they have a right to erasure, which is often difficult in research. There have been experiences where researchers use consent for lawful basis for processing, and one subject comes and says, we want our data to be deleted. And by then you have integrated the data, you don't even know where the data is, it becomes a problem. And they will have a right to portability. If you use public task, the difference between consent and public task here will be this. You see, if you use public task, you are not obligated to actually fulfill this right of erasure. So the data subjects do not have that right to erasure. And you're also not obligated to fulfill the right to portability, because they will not have that right, because you've not used a different lawful basis that does not allow them to actually ask for that. So it's important to understand what lawful basis that you need to select for processing your data. And then beyond identification of lawful basis and some of the technical measures that we have identified, it's also important to create organizational safeguards. And one of those organizational safeguards is data use agreements. And this is an agreement where you detail liabilities and responsibilities for both the data processor, the data controller, and yourself. An example would be if you go to eBrains research infrastructure, and you want to collect personal data, that's neuroimaging data of a living human being. And we have data use agreements there. If you collect that data and download it on your system to use, you're not a processor, you're a controller. You control the purposes and means of the processing. And that information is on the DUA. If you sign the DUA, you're now controlling the data. If there's a data breach on your end, you will bear the responsibilities of a controller. So it's always important, because sometimes you can't control what people do with the data you share with them. You might have loads of data and you share with people and they do whatever they want to do with it. If the breach actually emanates from them, if you don't have a data use agreement with them, they can claim that they are only processors and not a controller. And then you bear the responsibility. It's always important to have these agreements put in place to safeguard you and your organizations. And also data transfer agreements, data processing agreements, and sometimes there's a possibility of joint controllership, 2 or 3 entities or individuals are controlling the purposes and means of the processing. It's important to identify your responsibilities in the data processing pipeline. And then I think I've mentioned this earlier. The first technical measure often to protect the privacy and potentiality of the data subject is anonymization or pseudonymization. As I said, anonymization will be the removal of both the direct and indirect identifiers from the data, and the pseudonymization is removal of the direct identifiers alone, and the indirect identifiers will still be there. So if you remove the identifiers and then have the key somewhere, there's a possibility of re-identifiability with the keys that you have somewhere else. That is pseudonymization, and that is what de-identification also is. And then encryption, where it is possible, if you can encrypt the data, both at rest and on transit, that makes it more possible to secure the data. And in the face of the law, if you do encryption, it reduces your liability in cases of breach, because you've done something extra on top of establishing other regular technical measures to protect the data subject. And then keynotes here is that the GDPR is not an excuse not to share your data. Though the law in general, not just the GDPR, the data protection laws are not the excuse not to share your data. Consent for the research protocol is different from the consent used as a lawful basis for processing. And consent is not the only legal basis for processing. I cannot emphasize that enough. And it's not usually it's not the only basis, and it maybe not the best basis for processing. And also, always remember your duties to the data subject. You have duties to the data subject because they have rights that they can actually ask from you. So in summary, what we can do in terms of the law is identify the lawful basis, create organizational safeguards, and establish technical measures to protect the data subject. And then in terms of research infrastructure that can help us to do this, there are so many research infrastructures putting in place some of these elements into the curation process now. One is eBrains. Another one might be BrainLife, because for a number of months and years now, we've been working with BrainLife to set up some of these DUAs and all the technical measures to help you to address some of the ethical and the legal issues that we've identified here. So this table might help in terms of understanding what I mean by pseudonymized and anonymized more statistics. Let me see if it helps. So in terms of direct identifiers, if you're dealing with neuro images now, in terms of direct identifiers, the brain prints are still there. The names, the brain prints are still there. The indirect identifiers, sorry. The indirect identifiers are still there. But then, and also it has a high probability of, so this is the raw data. If you have the face still there, not defaced, if you have the brain print still there, this is raw data. You do not share, please do not share arbitrarily. If you deface and the face is no longer visible, but the brain prints are still intact, the chance of identifiability is medium. So you can surely know that this is pseudonymized data or de-identified data. But if you can eliminate the face and eliminate the brain prints, then that is fully anonymized. But then is that useful for research if you do that? That is a question that we have to ask ourselves. But I don't want to go into the case study now, but this is a time for questions. If you've not asked any question, I'll stop sharing and then answer your questions. Yes, Angelina?
Sorry, yeah, if you don't mind, I have another one. First of all, thanks for that. That was an excellent talk. then what would you say should be done in cases where people are only using image-derived phenotypes? Because that's becoming a lot more common in secondary data analysis when using big data repositories like the UK Biobank. Oftentimes, researchers are never going to ask for the raw data. They literally just use tables with numbers. So then my understanding is that it's almost impossible to re-identify someone because these are just metrics based on their brains that you're never going to see. What do you think is the right thing to do?
So, in most discussions with people, a few people in this space, there are some people that believe that the idea of anonymization or full anonymization is not possible, right? Even with just raw statistics. But I agree with you. Currently, as it is in the law, in any data protection law, anonymous statistics, it's perfectly fine to share. Perfectly fine to share. The first question any DPO will ask is, from this data, can I identify the individual? If the first answer is no, and the re-identifiability test, it stands, it's fine. Anonymous
Yeah, I guess the
statistics.
problem there is linkage because, of course, typically you can link that data to demographic clinical information, in which case, of course, the picture changes quite a lot, but still, sometimes it is a bit of a challenge because I'm mostly a secondary data analysis type person, so I never look at raw brains. I mostly just use numbers derived from brain measurements, and then sometimes it's tricky to know what's the right thing to do or whether you should exclude certain people if they withdraw consent sometime into the study.
Yeah, if they withdraw consent, it depends. As I said, it depends on what lawful basis you're using for processing. And that's why I always tell researchers, identify your lawful basis, document it as early as possible, so that if you get this request for withdrawal, you can surely present that to them, to the data subjects that consent is not my lawful basis for processing here, it's public task. So you can ask for this or you can ask for this. So it's very important in that sense.
Thank you.
I wonder if there's a question in the room. Is Noah there? Yeah, I can hear you, yes. I can't hear you again. If you can go close to the microphone.
Thanks a lot for the talk. I guess two questions. First, it's never a 0 or 1 in terms of re-identifiability or even like for image-derived data. How much you can re-identify a brain with like a segmented areas of the brain. It's a judgment call, and as you said, so the question often is who is making the decision that this is anonymous or pseudonymous enough, and as we don't have a 0 or 1 decision in those cases. So the question to me is really who's making that decision and with which incentive that decision, how the incentive of that decision. So that's the first question, and the second question is, do we have examples of actually lawsuit or effect of breach of in your imaging of there's a brain that has been released and somehow has been linked to a name? Do we have an example of a lawsuit or nefarious consequence of a release of a release on that? Because often those things are kind of taken from examples of in the society. What are the consequences? So I always feel that there is a lot of fear, but the actual impact and risk is not as well understood and evaluated. So those are my two quick questions.
Okay, please correct me if I didn't represent your question correctly. The first question was who makes the decisions whether or when a data set can be re-identified or not, right? Who makes the decision?
Which incentive? Yes, who makes the decision?
Okay, who makes the decision? Yeah, so, and this is always a problem for European, for any institution at all, because the GDPR does not, or the law does not identify the right person to make the decision in the institution, but it has the concept of controllership. As a controller, everything depends on you. All liabilities, all decisions will have to be made by you. Or processors make decisions based on your instructions. Also, as a processor, as a controller of the data, oftentimes you're not the controller as an individual. Your institution is also part of that decision you're making on data. And that is why most institutions, including universities in Europe, especially in the UK, will have to be sure of the types of decisions you're making in data processing, especially in international collaborations. So that you don't do anything and they are liable for it. So as a data controller, you have to make the decision. If you want to conduct that re-identifiability test, it's on you to make that decision, because in cases of breach, you will be the one liable for it. As a processor, you're only making decisions based on what the controller tells you to do, the instructions of the controller. So if you identify your role in the data processing pipeline as a controller, then you have to conduct the DPIA to ensure the DPIA will provide you with an information of whether you need to conduct a re-identifiability test or not. But if not, as an individual or as a processor, I don't think you should worry yourself about that, because everything you're doing will be by the instruction of the controller. The second question that you asked is about, do we have use cases of breach or negative consequences in neuroscience or in research in general? Unfortunately, the GDPR doesn't work with use cases. The GDPR provides the regulations and provisions. It does not have to wait for use cases to interpret some of these provisions. And that is why institutions or research institutions are proactive about it. And this was a major problem at the beginning of the GDPR. Even companies didn't know what to do until some of them started being fined. And then that's when they started to understand that they don't need to find a use case before they actually do what they're supposed to do. So institutions are proactive now. And that's why most institutions in Europe are stopping the sharing of neuroimaging data, or defaced neuroimaging data proactively and not reactively. So the GDPR encourages us to be proactive and not reactive. I agree with you. There might not be a use case at the moment that I can actually, somebody can point to and say, yes, this is one where there was a breach and there were negative consequences. I agree with you. But the law might not actually wait for us to find one to fine us, or maybe you have a reputational risk involved.
I wanted to actually add one more question to you, which relates to the UK Biobank. The UK Biobank recently changed the data access rules. So even if you have a data use agreement with the UK Biobank, you're now no longer allowed to download that data. Instead, you're required to process that data and analyze it on a cloud platform. And I wonder, does that affect the issue of controllership? Now that the data is not stored on some machine that's here on campus, it's instead stored on their servers and then analyzed there?
Yeah, so this is very important. And I think the reason why they did that was to control the activities of people who become data controllers in their own institutions by collecting their data. If you read through their terms and conditions, there might be some of these things outlined there. If they have changed it, if they have changed the process of download, you can't download, you can only process there. It's because of that. And the wording of the terms and conditions will change because of that too. And in that terms and condition, that means you find out that you're only a processor. If you're only a processor, you don't have to worry about some of this. If you're just a processor, you don't have to worry about. If you're a controller, that's when you start worrying about what do I do? How do I protect the data in my custody or not? That's the difference between a processor and a controller.
Great. more questions here from Zoom? Not that you will thank Damien for this presentation. And we're going to break now until 30 past the hour. We'll have Docker here, there, Docker there, and Python data visualization here.
Okay, thank you very much, and see you guys.